Yes. So I'm mentioning for listing of a new matter day after tomorrow. Huh? For listing of a new case day after tomorrow. Of like, I am 23 matter. Concept of the petitioner side. We need further 2 weeks time to file our I visit the member book. I can quit. Para 23 your father? I was right, Mr. P. Bharadwaj. P. Bharadwaj appearing for the IOC is granted a further 2 weeks time to file affidavit of police. Is the matter. Okay. The consent of butterfly madam, side experiment on agenda part 34 madam. But each time may kindly be allowed to file a time. CPC file by here number 429. Mr. Arthur. Sharma is granted 3 weeks time to file. Yes, I reply. This is the matter. Correct. Let it work. On behalf of Mr. A. Thakur Madam, I recommend item number 24 and 25 madam. He's on very well. I also informed the petitioner. 2 weeks time maybe. Why? Follow the Mr. A. Thakur, he's on very plan. I've been in. He's on? A. Thakur Madam. What about him? He's on very plan. His letter for the expired. And who's for the other side? The each Pura Goya. But I've informed the petitioner also. I'm nowhere in a matter, but I've been informed. Has he objected or has he? He has given the consent. But yes, it's only requested that a fixed date may be given. Right, Mr. M. Smith. Then a counsel appearing. No, appearing on behalf of Mr. A. Thakuria. Pays for a judgment on the ground that Mr. A. Thakuria is under bereavement. But we also submit that he has taken the consent of Mr. H. Buragohai. H. Buragohai. Counsel for the petitioner. This is the matter on? Any date, how long will he be under bereavement? But he has requested me for 2 weeks now. It is. Even if it is. 10 C. Malam. Consider of the other party number. I beg to mention item number 32, my lord. Here they supposed to file it. They will not file it. They find out maybe some another. No. We will take it up. Not constant lots. Huh? Constant was not given lot. I told that. Leading at what 84 question. No, we'll take it up. We'll see. You will. Already covered lot. I know. Because 22 for picture. He wants an early lot. He has a particular. Huh? Take a 84 question living at okay. He is absent, so he instructed me to take a time. One next week at 26 months. This is fisheries cancelled in 22. Yes, Manoj. So, 22, division bench recently after the he submits that this is distinguishable factor. Doctor is actually he's caring about his signal is not there. It is your final option. He's scared of. He knows that it will be distinguishable. Distinguishable some points. Maybe distinguishable. So he will argue, my lord. That is why last occasion a time is given to clarify them to final executive. They also file. And it's not hard, my lord. Next week. Why? Why next week? Is he not coming tomorrow? Is he coming to court tomorrow? And he is out of situation for some personal. He's out of station for how many days? 1 day, my lord. So I told him. Friday is to come. A German prayer has been made on behalf of Mr. AK for Pastor Leonard Council for the petition on the ground that he is out of state. Mr. What is the name? Mr. M. J. Barwa. Yes. Submits that the matter may be listed on Friday. Mr. P. Sharma. Appeals for the hearing of this. This is a matter of Friday. He submits that the matter is a covered matter in terms of the Judgment and order dated 6/5/24. Passed in WA number 366/2022. Put this in the file. Put this in the file. Oh, I'll keep it. So you want it back? No, no, no. Put this in the file. This is item, wait, item 32 here. Yes. Huh? You wait, you wait. We'll see.
But the claim from listing this method for admission, this is the 2020 method. All
You
payment.
wait.
Okay. Lakshman, the last occasion also they took time on this. Lakshman direct.
Wait, let it come. Let's see. We'll wait. Huh? So what? This matter pertains to what?
Cancellation of a tender lodge.
Huh?
Cancellation of a tender lodge.
Have you issued a new NIT?
Lordship?
Have you issued a new NIT?
No, Lordship.
Why?
It is on the process, Lordship. Okay. Because
Is there any stay order?
no, Lordship. No stay order.
When do you want? Why next week? You have filed it when? You have not filed it. What affidavit? Reply. There's nothing here. This case, huh? Is there anything left to decide in this case? Since you're prepared, we'll hear you. You're filed, you'll be knowing what you're case. Why? We'll hear you. You're ready with your affidavit in reply. We'll hear you on that point. Where is he? What is your name? Mr. S. D. appearing on behalf of Mr. S. Bhatt Thakur, learned counsel for the petitioner. Petitioners. Submit that affidavit in reply is being filed today. He accordingly please that the matter be listed on another day. And this is the matter on Monday. No adjournment will be given on the next day, and the matter will be decided on the basis of materials on record if the affidavit in reply is not filed by them. Leave here.
Yes, we got it. I get to mention item number 27. It is after Mr. N. NXT is out of station.
Who is out of station?
Mr. N. NXT.
Okay, right. Adjournment prayer has been on behalf of Mr. N. Anik Singh, learned counsel.
In June.
Learned counsel for the petitioner. This is the matter after 2 weeks. Yes. Regarding what? Huh? Huh? You? Vacate to vacate. To evict. Whether that matter will come here? Eviction. Eviction matter bench 5. Go there. Huh? Item? Huh? 10, 11, 13. Yes. What do you want? Why? Wait. We'll see. Let me find out. Wait.
Huh? Why? How long will he have personal difficulties? Where is he? Is he coming to court tomorrow? Day after tomorrow, is he coming? He's coming. List the matter on the prayer of the on the prayer made on behalf of the petitioners council, applicant slash petitioners council. List the matter day after tomorrow. Non-payment of new case. Huh? Old case. Give a date. Yes. Tender dated 5/12/23. Yes.
And there was a collision of three states for the extent. For the extent, now 27 to 23. The submission is said to have an RTP request from the respondent of five for the highest one crore of the order. The petition of ISRO of the second and there were other down. Now the petition was raised to the response of five. Now the response of five found after verifying it, the 60% of the petition is endorsed. So he decided to withdraw his settlement. He decided to pay an application for regulated ultimately withdraw it. Now I find it not. I think the second part. Why is that's my thing. Today I'm asking for total information. My date is the table is about 98 to 98 lakhs subscription of 77.
And his rate was
His rate was 1 crore 91. So that's it. If today they are, then you have to the rate is quoted by the petitioner that is respondent, you have to give it. That may be it. But ultimately they
are you willing to give that rate?
so now I can't. Okay.
No, you have to also give a you also have
I
to
no, I have not.
then we
We
should have
can't say.
we should have asked the client before that, before approaching this court.
I have taken a statement. That's not that. Four. We have also find it very serious something for that. That means there is
What is his writ petition number?
this seven of the six.
That is respondent number 4.
Yes.
He's a party here.
We will
Yes.
notice my follow.
Okay, right. Heard Mr. Dida, the senior counsel, appearing for the petition to submit that in person to an NIT dated 5/12/23 and corrigendum dated 13/12/23, the number 1 Chalkova River fishery in Barpeta district was settled with the respondent number 5. However, the respondent number 5 withdrew his offer. Yes, sir. The petitioner's counsel subject that the petitioner who had quoted rupees 98 lakh 77,770 and as against the bid of the respondent number 5, which was rupees 1,91, 1,91,000, should be settled with the fiction, as he is the second highest bid. He also submits that the respondent number 4, who had submitted a bid amount of approximately 49 lakh, 00002 has also paid for settlement of the fishery, and in this regard, he has filed WPC number 607/2020. If you notice, returnable in 4 weeks. The petitioner, Mr. P. Sharma, accepts notice on behalf of
Reference number 1, 2, 1 and 2.
1 and 2. Yes, 2 appears, Mr. M. Chetia.
And 3.
Mr. M. Chetia accepts notice on behalf of point number 3. Petitioner takes steps for service of notice upon the respondents number 4 and 5 by a registered post within 3 days. Full stop. In addition to the above, the petitioner shall also serve notice upon the respondents number 4 and 5 by that system.
Extra copy. Fine.
And file affidavit of service thereafter. This is a matter of that settlement was because
They could not deposit the case.
the
And that was cancelled in 14/7/2023.
where which page?
Days minus 40.
First tell me what is the NIT dated?
That was
Well, my objection is not here. It's filed on 16/5. So let's see it in another paper. Sixteen-5. On Friday.
Okay, right. It says that learned counsel for the respondent submit the respondent no, counsel for the writ petitioner submits that his objection to the interim application as is not on the record. They didn't need to pay the same on record. This is a matter of time.
Friday.
What? No. Huh? Oh, Monday.
certain code I have problem with. Very can like it. Yes, I have metric of what put up about now. Put I
This is a matter. What about on? Okay, when do you want? 30th. 30th Thursday. Give me the writ petition. Okay, now in item 3, who is the writ petitioner? Here and in item 40, who is the writ petitioner? Here the same.
I am for the IOCM the respondent.
So what is your case? NIT dated
18/11/23.
18/11/23. And that is for what?
For
Hiring of vehicles.
hiring of vehicles, 1 bus, 7 400. The work was awarded to another CFS client on 27th of May 2022.
Just a minute. Allotted on
27th of May, 2022,
27th,
27th of May today,
2022.
2022 for a period of
But NIT though, NIT did it?
that is via the initial NIT. I'm talking about the background, I don't why
What is the initial NIT?
the initial NIT is 4320.
4322. That's so work already on 27, 522. And this is going to expire when? Validity of the contract?
So initial period for 2-year term today expired. 27 May 2020
2 years doesn't expire yesterday.
expired yesterday.
Expired yesterday.
That's not correct. It is June. In respect of 7 vehicles, it is June, and in respect of parts, it is September. I'll show that.
Okay, anyway. According to him, 2 years term, so 2 years so it'll expire today. Yesterday. Oh, at the most today. Actually, it's yesterday,
Yes,
actually, 2 years.
yes.
Expired. Then,
Then, my lord, on the 15th May 2023, a communication,
so he's challenging the NIT.
he's challenging two parts. A communication was issued on 15 May 2023 by the IOCF,
Just a minute. Communication dated
15 May 2023,
15 May 23.
page 103,
Yes.
103.
Of which
Of
repetition?
the first writ petition 7005.
Yes.
This is an intimation for closure of the contract given to the petitioner, providing operating 1 minibus and 7 boleros. This is in continuation to our earlier letter reference dated 18/1/23 regarding intimation for closure of the contract for the job, providing operating 1 seater minibus and 7 number bolero. The ATF Guwahati Refinery by work order dated 27 May 2020.
So this is okay. So
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 the
you were trying to close up, so the contract can be terminated if you give a month's notice or something?
There is no provision for one's notice. We have simply intimated that it is going to close on 31 December 2023 or notation of a new contract, whichever is earlier. This is not even a technically, we do not even call it a notice. It is an intimation in technical sense. But this has been challenged by the petitioner in the writ
So
petition.
there's nothing wrong with the challenge. His term is not expired.
At that time, it had not expired. It came because he had suffered prejudice because after the floating of the tender, his work was going to be terminated midway, so the prejudice was clean. So, my lord, when the writ petition was lifted, we have not filed any affidavit in opposition, I will say. We conceded to the prayer of the petitioner that let him be allowed to complete his work order for 2 years.
So he filed the representation.
He filed the representation on 4th of May, 2024.
4th of May? The communication is of 15 May. How can he write a few,
Well, he files a representation for being allowed to continue his work.
after the intimation, whatever that you have written to him
Yes.
on 15 May,
Yes, sir.
did he submit any representation subsequent to that letter?
My lord,
The
that is on
intimation.
30 November 2020,
Page
last page 110.
This is his letter in reply to that 15/5.
Yes, my lord. He has not submitted any representation in the tweet. He has not annexed any document. The government has been made that IOCL is not going to terminate midway. That understanding has been reached with the authorities. That a verbal
Okay,
averment.
then what happened?
The tender was floated on 18 November 2023.
Ah.
He came before this honorable court.
Let us see the tender page.
Tender page 104. It's the same format as the earlier tender. Clause 4 again, 24 months from the date of site handover. So this envisages the future action of 2 years there. So the petitioner naturally claimed that his work order, which was supposed to close on 27th of May, that would be terminated midway. And the prayer in the writ petition specifically mentions that at page 21 that one prayer is to be allowed to continue his work order. Page 21,
Let us see the
the prayer. Page 21, all for the relevant.
Impugn
records.
letter dated issued by notice in that's all for the dated. Work order dated 27/5/23,
This is a typographical error. That is 20.
22. Zero completion of the contract period. So let us see the work order. Where is it page?
The work order is again at page annexure 2. That page 29. The relevant clause number is clause 4 at page 30. Completion time. Please note that the time allowed for carrying out the work is 24 months and same shall be reckoned from the date of handing over of site.
So when was the site handed over?
That is reflected in the order dated 4/12/23 of this honorable court by Ernest Senior Friend's submission, his own submission.
Let us see.
That is the-
Page 412.
that is the order, Justice Saikya's order. Two orders are there. Second one.
The Learned Senior Counsel submits that the date of handing over of the site would be the date of issuance of the work order.
But that is not right, but I think it is not correct. On the record, I'll show. Anyway, I'll show it. Either way, but because work order was given for the delivery of vehicles, I'm required to, I took the work order. Required to place a brand new vehicle. It's not that thing, man, it is a brand new. Your Lordship will kindly see, first of all, your Lordship will see what is the application for vacancy. This next question.
Anyway, that is now all. The only thing, we'll allow you to complete your contract. Then.
No, not that, my lord. Your lordship will kindly see clause 1B.
Hmm.
1B.
Yes.
Clause 1B, page 40,
Page?
40. Man, if he has finished, then let me place it, man.
Just a slide, small
Also, let me finish it, man.
Yes, yes.
I'll finish. Well, the date of handover is also mentioned as being May 24.
What do you understand by the words handing over site? What does that mean? What does that entail?
My lord, in this space, there is a supply of vehicles, so there is no site in question. On the date of issue of work order, if he is ready to supply the vehicles, is the date of that work order. And that is the pleading.
There is no site to be handed
There
over.
is no site to be handed over. There is a pleading there in the second writ petition. In fact, in the synopsis, again, this has been mentioned of the second writ petition. Second page of the synopsis, my lord will permit me to.
Yes.
Second page, second paragraph. As per work order dated 27 May 22
Second page.
of the second writ petition, synopsis of the second writ petition. They have repeated that effort.
Yes.
As per the work order dated 27 May 22, initial 2 years period of work will be expiring in the month of May 20. And the petitioner by a letter dated so and so requested for giving 1 year extension of the same work.
Let us see this letter dated 4/5/2022.
4/5/24. At page 109 of the second writ petition. Manner, I may read. With reference to above mentioned subject, I am executing the above mentioned job which is having initial period of 2 years from 1/6/2022
to 31/5.
31/5. Again, he's saying 1/6. So there is again a conflict in each effort.
Anyway, so we will accept either one of the dates. The later one, in fact.
Later one. On 31st May, let him complete.
Yeah.
And the period of
Just
extension.
a minute. And what is that page that we read out just now? Page?
Page 109 of the second reading. An extra 50.
Okay.
And the extension clause which the learning friend is relying on, it is that clause 8, my lord.
Page
45.
of the first wish petition.
First reading. Clause 8, time schedule and working time. Initially, the contract period of work shall be 2 years from the date of commencement of the work and the placement of vehicle. Work order may be extended for 1 year on the same date of the contract. The usage of the word shall denotes a mandatory page 44. First clause, clause 8. The first line uses the word shall, which means the contract
Clause 8 starts with the rates. The rates quoted.
page 44 in the first reading. 7005, which is written.
Correct. Clause 8 or clause 7, what?
Clause 8 for time schedule and working time. The heading is time schedule and working.
Okay, page 40.
So the first line mentions shall
Yeah.
be 2 years, which is a mandatory that it should
From the date of commencement of the work
work.
and
And
placement of it.
and the work order may be extended. The words are in contradistinction that there is a discretionary, it may or may not be. It cannot be implemented at the instance of the petition. A mandate
Correct,
must be the
correct.
mandate.
May be extended. That's all depending upon you.
That is my sub.
So, yeah.
Page 40, same NIC,
Page 40, yeah.
40 special conditions of contract. 1B,
It's, yes.
1B. Clause D, my lord. These are 7 Bolero and 1 my lord Thar. D, my lord, your lordship. The vehicle should be of brand new model registered after date of award of the council. Thank you, lord. D,
So,
I'm coming, but lordship has taken a view to it.
no, it's not that. It's not that. I'm trying
Page
to understand.
45, your lordship is going to say again. I'm
Yes.
reading it.
It should be placed within 1 month of receipt of letter of acceptance. When was letter of acceptance given to you?
27.
27.
Work order was given to you.
That is equivalent to an LOA.
Huh?
That is equivalent
Work
to
order is LOA.
Then
So when was the vehicle placed before them?
and after permit.
When was that? When was
Permit,
the?
your lordship will get it at page 54. Without permit, I cannot place the vehicle.
But then why are you taking a different stand in other?
That is, I think, wrong.
How can it be wrong? You have made something.
I'm writing it.
Okay, page 54.
54.
Huh?
Technically, when the petition is not mentioned, they filed an application for vacating your lordship.
No, but we'll decide your petition. We won't decide.
I'm not going technical.
We'll only decide.
54.
Hmm.
Let us go like this.
Yes.
54, your lordship, this is a registration. It is registration date, my lord, 11 June. As a lord, 11 June, my lord, that fourth line, registration that receipt, vehicle class, receipt from both your, etc., 11 June. As a lord,
Yes.
Yes.
This is for what? This is for what?
Registration of the vehicle.
Which vehicle?
This is Bolero.
Bolero number?
Bolero number, only chassis numbers, etc. They are
No,
vehicle
AS01 is there. AS01 PC 233.
G6, chassis number so and so. And your lordship will kindly say next. I'll take your lordship to page 57. This is the permit. This is on the basis of the letter given by the IS.
Just a minute. Page 57.
Yes.
Page 57. Yes. This is for what?
This is for permit, because without this permit, I cannot place the vehicle before that. It is from 30th June to 29th June 25. Below, my lord. Then to carry personnel related under IOC.
This is for Bolero again.
Yes, and then your lordship.
It's the same, it's the same. It's for the same vehicle.
The same vehicle to carry personnel related under IOC. And your lordship, what? Interstate route 30th June to 22 to 29 to 25.
Yes.
Now up to page 81, your lordship.
No, let's go to all.
Mala-
We cannot go.
Mala?
Next one, let us see.
Yes, next
Page
one,
58.
sir, Page 55.
Page 61.
Huh?
Same purpose, another purpose.
Page 51, 58, same permit, same date, up to that. Only for different vehicles, my lord, your lordship will find up to page 81. Same thing. Vehicle numbers are different, otherwise date and the permit dates are same.
What are the vehicles that you have given?
Bolero, 7 Bolero and 1 bus, 4 bus.
What are the numbers all matching?
Different.
Then it is different. So these according to you are all registered on 11 June.
Yes, and permit is for that thing.
From which period? From 11 June.
30 June 20.
From 30 June to 29 June.
Yes. This is in respect of the 7 vehicles. And in respect of the force, your lordship will kindly see page 82.
Yes.
82, this is the date your lordship will kindly see, 27th October 23.
Page 82, registration is 11th August.
Yes. Receipt date is
Registration is 11/8/22.
27th October 23.
Mhm.
And permit your lordship will get it at page 85. Twenty-second September 22 to 21 September 25. So virtually, my lord, your lordship takes in the permit into consideration for 7 Bolero, it ends at June, May, June. And for the
It
fourth,
is not 29 June. That's the permit. But your contract ends before that.
30th June. 30th June.
No, 29 June.
29. And in respect of this vehicle, Fords, my lord, page 85, your lordship can see, interstate route from 29 September to the Fords Motors.
But
85.
then as per the terms of the contract,
2 years from the date of site, but unless I get the permit.
date of site, what do you mean date of site? Date of site means permit.
That they are saying site is not there, but without permit, I cannot place. The lordship knows that. So after permit only, after registration, now they have placed.
But
the
then
plan for the-
you're taking different stands. 3 different stands you're taking now. Before this court.
And that if they,
In the-
if they file an affidavit in opposition, or if they file an.
No need, we are only relying.
Showing from the record of the.
No, we are relying only upon your statement. Your first statement before the court was that the letter, the work order is the date of the start of the contract. That is your stand. Then the writ petitioner writes a subsequent letter saying that it is till 30th May.
That is.
Now you are
that
taking
is-
a
I
third
think
stand.
That is not correct. Madam, I'm just placing from the record, subject to what you know. Because this, I have to, yesterday night when I was going through all these things, I find permit is dated so and so, if the client was, the contact that they said, yes, after getting permit only the vehicles were. See, it is not possible, unless you get the work order, then you place a brand new vehicle. You'll have to place it before the authorities. The vehicle comes, you'll have to register, you'll have to get a permit on the basis of the letter from the IOC. So this is the facts.
When did you start commencing the work?
Vote from the, in respect of the Bolero from that, from the date of permit.
And your bills, yeah, so So you have not submitted any bill prior to the permit.
This aspect of the matter, unless they show it.
Let me see the bill.
Well, in this page, the order of 4/12/23, again, order of 4/12/2023,
Yes, for sure.
page number 3.
Just a minute. Page number 3, yes.
5 lines down from the first, right? The petitioner was the shortlisted bidder allotted work order in 25 pursuant to the issuance of the work order. Petitioner
Just a minute. Wait. Order dated 4/12/23. Which paragraph?
it is page number 3 from the certified copy.
Page number
available.
3,
Yeah,
yes.
Paragraph 3. Paragraph 3.
Paragraph 3.
Paragraph 3.
Paragraph 3 is on the first page, yes.
Yes, sir. 1, 2, 3, 5th line.
Yes,
The scope of the work is
yes,
so and
yes,
so.
yes.
Petitioner was shortlisted, bidder allotted the work order, dated 27/20. Pursuant to the issuance of the work order, petitioner proceeded to carry out the contract. So by supplying the vehicles mentioned in the NIT, they supplied it beforehand. It is also
Ah.
submitted that as
Okay, before the scope of the work is hiring of the petitioner was the short end of the work. That procedure by supplying person to the issue.
In synopsis, we have written up to June 24.
Huh?
Synopsis, we have written.
Correct. You see, you are making submissions beyond your pleading.
No.
That is the problem. Now let us see one thing.
Let me
Can
say
you
that
can you bring out the bills they have submitted? They must have submitted bills. From which period are they claiming their bill?
the bills followed, I have to find out that.
Because that will clearly spell out from which date they.
Yes, yes.
let the record be compared, not five days.
I take the instruction.
No. At the most, you will get only till June or June.
No.
For the Bolero, you will get only till June anyway. You have got nothing more.
What I am submitting, my lord, your lordship can take the second case. First case, your lordship, may I place the record on the material. Clause I, 8, your lordship has seen page 45. It is extendable by another one.
That is up to their discretion. That is
Yes,
nothing there.
That your lordship may take a view of the matter. But
That
there
is,
is in the second case, there is a direction to consider the representation for action.
so you consider take a decision. What is
First, there's a writ appeal and a tender already pending. So
writ appeal is pending?
It is their file
writ appeal we filed it for
Against
vacating
this-
of the interim order.
against it.
Modification. Because my lord, the question is, madam, we are not against the completion of the tenure, but to complete the tender formalities takes another 1 month. If it runs out,
It's
then
okay,
if it
but
runs
why,
out, then
why
we are-
don't you take a decision on their application for extension? You just say, no, that's all. We don't.
we close the writ petition and we take a decision on that, in respect
The
of the
writ
second
appeal.
writ petition.
Ah.
The first writ petition.
Yes,
was-
you take, you
The
first writ
NIT
petition
should
was
be-
reserved on a different ground.
NIT should be satisfied.
Huh?
These fresh NIT.
Doesn't have to be satisfied. That
Then I will.
the fresh NIT will be the outcome of the, will depend upon the outcome of this, this.
Your lordship will
Oh,
continue.
no, this is only a dealing time. You see, very simple. You just bring the record. I just want, this is only for the purpose of clarifying or certifying from when the contract really starts. Because as per the documents on record, as per the contract agreement, the tender, it shows that from the date of commencement of the work. Now, date of commencement of the work is taken 3 different times. So the bills will clarify from which date they have made a claim for the bill. One the thing is that then the end of the matter.
Manager takes it through, I'll have to accept.
Okay, this is the matter. Yes, so,
But I haven't finished my argument.
you know, I'll hear you, don't worry. That's okay. Okay, just before that, I'll just dictate. I'll just
Here,
dictate the
this
length.
man has taken loan from the bank.
Whatever.
No, your lordship-
Everyone has taken loan from the bank.
your lordship-
Everyone takes loan from the, I've not heard of businessmen who don't take loan from the bank. If they are businessmen, they all take loans from the bank. They don't use their own money.
Here in
That's why the,
similar situation, the same petitioner has been given extension. So therefore.
maybe. Oh, but where is your right?
Okay.
7 and 8? Oh, you, Or you leave, we'll wait for you there after that. Huh?
He's a formal party.
Okay,
and
okay,
a
okay. Yeah,
pro
no,
forma
no,
party.
right, heard, mister? Huh? This item that I'm hearing just now, item 2 and item 40. Okay, 40, right. Wait, Mr. Das, wait. Heard Mr. B.D. Das, Leonard Senior Counsel. Assisted by Mr. Keshav. Also heard
And
Mr.
Barua.
N. Barwa,
And Barua.
Learned Counsel appearing for the
IOCL.
IFCL. And Mr. What's his name? Huh?
AK Doctor.
A.K. Datta, CGC, appearing for the
Respondents number 7.
7,
Respondent number 7.
7
Yeah, item 40.
in
Item
item 40, yeah, in item 40. Good. The petitioner is agreed by the issuance of the NIT dated.
Only in the second case, order is there in detail.
Acha.
Yes.
Already here.
Yes, in detail. As regards consideration of the representation, they are to do that.
That is for the second point.
Second, regarding action.
What about this? NIT dated 18/11/23. Issued by the respondent ICOL. During the currency of the contract work allotted to the petition in WPC number 7005/2020. Next up. In WPC 26515 of 2020, for 2020, the petitioner seeks for a direction to the respondent, seeks for a direction to be issued to the respondent authorities, comma, to consider the representation submitted for the extension of contract hiring of the petitioner's vehicles for another 1 year, comma, beyond the contract period of 2 years. The fact of the fact of the case in brief is that in pursuance to an NIT dated 4/3/22 for hiring of one number of 14 plus 1 seater minibus and 7 brand new Boleros or equivalent model with drivers for 24 months on 8 hours duty, comma. The petitioner was awarded the contract work wide work order dated 27/5/2022. During the subsistence of the contract work, comma, the petitioner was issued a communication dated 15/5/2023 informing him that the termination of his contract would occur on 31/5/2020 as there was a new contract being considered in the office. OFFINT, yeah, office. Yeah, good one. Thereafter, no, good one. Thereafter, the respondent IOCL issued a new NIT dated 18/11/2020 for hiring of vehicles for another 2-year term, as had been set out in the earlier NIT dated 4/3/2022. Next part. Being aggrieved by the fact that a new NIT had been issued during the subsistence of the contract executed between the petitioner and the IOCL. The petitioner submitted a letter dated 4/5/2024 to the IOCL requesting that what is that? No, the letter dated 30/11/2020. 30/11/2020. Requesting that the NIT dated 18/11/23 that should be cancelled along with the communication dated 15/5/20. The petitioner further praised that he should be allowed to continue his contract work as per the work order dated 27/5/2020. Next part. The counsel for the IOCL submit that the contract for hiring of vehicles started with effect from 27/5/22 when the work order was issued, and the validity of the contract was expired on 26/5/2020. In this respect, he has also referred to the order dated 4/12/2023 passed by this court in 7/005/2023, wherein it is recorded by this court that as recorded as follows. Inverted commas, the learned senior counsel submits that the date of handing over the site would be the date of issuance of the work order. Well, the instructions are, it has started from the beginning, started from June, what I have been told, in regard to Bolero, in regard to June is what. From the 1st of June, it started billing. But I don't know, I fail to understand how permit was given in the month of June. But anyway, 1st of June.
The vehicles are actually, the point is the vehicles all for the contract they run inside the refinery.
I think they without registration, that's the problem. Without permit, without
Inside the
permit.
campus.
You see, you cannot, you'll have to, you see, some date has to be fixed. So the safest date would be the date you start billing and the date for which you have got money already.
June. Whatever June and force are getting.
So June, from 1st June,
Bolero.
Bolero 1st June. Now for the 4th,
First, they will have to see the records.
you take 2 o'clock. That's all, huh? That's all. Okay, then next, then the others, so if you can, okay. He submits that in terms of the third paragraph of the synopsis in WPC number 2615 of 2024. The petitioner has taken the standard, the contract period of 2 years in terms of the work order dated 27/5/2020 would be expiring in the month of May 2024. However, in the letter dated, where is the letter page?
4/5.
Huh?
4th May or the 30th.
That other letter was there, no?
The other letter is a page 109 of the second reading.
How about in the date now? How about in terms of the letter dated 4/5/2024, issued by the petitioner to the DGM bracket EMS, HR department, what is defined as the contract period of 2 years was from 1/6/2022 to 31/5/2020. That's all. At 2 o'clock.
Well, I will rely on two judges and basic logic. Agree with you.
You see, we will rely upon the bills that you submit, from which date they have paid the claim. That's all.
Now, because of the clause that
Huh?
extendable by 1 year.
That's what they will decide. We'll give them a direction to decide.
That is good enough under civil law. Right.
That,
And but,
but then we want to know when your contract will expire. That has to be clarified. For
but
the-
regarding,
For the Bolero, it is clear.
Yes.
It's just right, Mr. BD Das submits upon instruction
billing started.
that as per as per instructions received, as per instructions that the billing period
For all the.
made for all the 7 Boleros by the petitioner was from 1st June 2022. Apply stop. In respect of the Ford
Fourth, I'll.
Ford.
Minibus.
minibus,
Force minibus.
Fourth minibus, the billing period started from dash. Give me that at 2 o'clock, end of the matter. Just put this. You come at again at 2. Huh?
If I require a week's time to collect steps on private.
What case?
This is item number 4.
It is 4.
If I is mistake in case of not, for not taking the step.
He is not taking steps twice.
No.
Why should I dismiss it? That was taking
Okay, so last chance maybe. Because
33, 22 and,
so only private, state was supposed to find the recipe because.
but he is not taking steps. Why don't you pay costs?
Okay, earlier it was taken, but it was taken itself. Then again, I was directed to take it. This is something. Protect the. Secretary is relating to tender. Tender was awarded to the private.
Sorry, Mr. Council. You see, all the office notes, we have not taken steps. Order dated 17/6/2022. No steps. Despite order dated 33/22. Now again out here. No steps despite order dated 20/06/22. Then again, no steps despite order dated 9/4/24. We have not taken steps once also.
Civic report is there. Civic take step because their office is in the Kamakya. But they
Yeah.
run in their office, thereafter you directed to reach them. That's not the report is there. I'll take within 24 hours.
This is a you're challenging your 22. Your financial bid as non-responsive.
Yes.
Now, in 2022,
Initially,
what has happened now to the case? Huh?
private respondent is running the security agency. Yes. And what the initial stay was granted in our favor.
And what is the period of contract?
It was probably 2 years. Now and
2 years.
agency has been.
That is what I'm saying.
We are
You see, Mr. Council. Now,
entitled to only compensation. If not, it is something.
no. You see, the issue is this. Now the NIT was of January 22.
Yes.
The contract period was for, wait, let me see. Work order was issued when? Then the petitioner is performing this fire presentation.
Definitely to see the first order.
You see, stay order was only till March 22. What is the status of the case now?
It is, the private respondent is running the
Since when?
since notice, before the interim order was passed.
Before the interim order was passed.
They filed,
And it is for 2 years.
notice we filed a contempt that was closed.
It is for 2 years. Now what remains?
No.
Now it's more than 2 years have passed.
Maybe if you,
Why don't you get some instructions? What is this?
our instructions are here, Lordship, but it is about the bidding process and it says that the bidding process.
Mr. Counsel, I just want to know one thing. The contract was for 2 years. That 2 year period has gone. As on date, it is finished. Now what has happened? Is there a new NIT issued? Is that person's thing extended or what? What remains? Is it infructuous? Why are you worried about the bidding process now? Why are we we might be dealing in a matter which has become infructuous. We take instructions. We take it up at 2.
We have taken steps for the year.
Huh?
Due to some difficulties, we have the file was mismatched.
You have taken steps. When? Show me. Show me the receipt.
It seems not yet. Today we have
Huh?
taken the step.
Huh?
Today we have given the file to the Modi of the for. By today itself, we have.
Also not provide us of our revised notice, we were non-issued the copy, we are not a.
Has the work been issued to anyone? Allotted to anybody?
Lordship, regarding that part, we are not.
August. Right, Mr.
I
I,
H.
Doctor. Learned counsel for the petitioner submits that he will take steps for service of notice upon the respondents number 4 and 5 within the course of the day. He also submits that. No. He shall also furnish extra copies of the writ petition to Mr. K. Gogoi. Learned counsel for
Explainer number 1.
1 to 3. 1 to 3. This is the matter after 4 weeks.
Make digital lordship, last located and lordship directed to file affidavit manner. Affidavit is being filed manner today. I have kept a copy about the counsel for the applicant manner and the now remaining of 9,44,590 rupees remains for manner to make payment manner. That is manner obligation has been raised by the register of property society. So that's why I could not release the amount manner. But I have filed the affidavit. The affidavit is being filed today. I have already.
Madam, we don't want affidavit. We want money.
Money, my lord, that's I have annexed in our affidavit. If your lordship takes of which I am going to file, my lord. In that, we have annexed the letter, my lord, wherein, my lord, the register of cooperative societies have raised some objections regarding, my lord, boundary wall, my lord. So that's why, and we have been directed not to release the pain until and unless that has been satisfied. So remaining amount of 9,44,590 rupees is, my lord, now we are to make payment. Because of my lord objection raised by the register of cooperative societies, we could not, my lord, the amount has not been released by the register of cooperative.
Madam, you are not fighting affidavit. You are not giving him money.
It's ready, I have served the copy.
And what have you said there?
Here, my lord, we have said that, my lord, the lordship will be pleased to, please,
Have you been given?
I have already started.
All has been completed in 2002. Something your position has been taken in 2002. In 2025, 24, they are taking out.
That is, my
The
lord,
satisfaction of the authority, they have taken position. I have
lordship,
seen
my
it.
lord, last one page, my lord, that, annexed to last page of my, today's affidavit. There is, my lord, that is the objection, my lord, from register of cooperative societies, my lord.
Without rectification, the construction will get delayed.
regarding my lord, construction of boundary work.
To the managing director, house head.
Yes, ma'am. To my lord, from Register of Cooperative Society. But they are to release the fund.
I think we'll call the registrar of cooperative societies here, which is record. If he finished the work in 2001, huh?
22, depending upon position,
So 22. 22.
24. So maybe after some time, my lord, so that it can be settled up. In the meantime, my lord, on 28th, lord, at the earlier page, my lord, 5,91,000 has been released. On 28th of May, my lord.
22 you completed, not 2000.
Not 2000. And
Is there some defects? Is there any maintenance period?
my lord, that because it is defects in the my lord, boundary wall itself. So that has been called and the petitioner has been called and my lord, he has been informed regarding that. My lord.
Why don't you cure the defect?
there is no defect, undisputed.
These are disputed sections of fact.
Lordship.
Then after, it not be petitioner. So it is the amount sum.
Is this not part of the record?
Look, that was the, because that was not, now.
You filed this, you filed this.
Let him bring it.
You
to
filed
the
this.
court, my lord.
Mr. S.K. Goswami submit that he needs how much time?
1
A week's time to file affidavit in reply. This is the matter after the week.
public.
My affidavit, my lord, I'll file it today itself.
Okay, Miss
You asked
Udas or
23 months.
so she submits that she'll file affidavit in opposition today. Then you say Mr. S.K. Goswami. Alright.
I'm like,
Mr. G. Bodarai appears for phone number.
Yes, Mr. Ali. President, this matter respondent of file and signed the affidavit, sir. He needs time to file the reply.
When did they file affidavit?
My lord. My lord, since the communication with the client was.
Filed in 21.
September 2000.
So you want to file it after 3 years. Your reply.
My lord, the communication with the client was not done, my lord. It is
With this, we'll leave the stay order. Is there any stay order?
My lord, no coercive action. Because regard the demand notice. My lord, 2 weeks time will be done.
You have been given 3 years already.
My lord, 2 weeks time, the last.
More than 3 years have gone by. You have not
2
filed.
weeks is the last.
Yes, what is to be done?
First is-
Why?
He leave it to your lord.
That means you have not read. Mr.
And Saira.
M. Sayawala is granted 2 weeks time to file affidavit in reply as a last chance. List the matter on give a date.
If you read. My lord, take the interim order.
Interim order to continue till the next day.
If you.
Yes, a petition was issued for maintaining and feeding the fees cattle, your lordship. Petition is annexed 3, page
What
25,
is your prayer in the petition?
your lordship. My prayer in the petition was to set aside the improved order by which the petition was postponed, your lordship, and to bring the petition to the logical end, your lordship, conclusion. My prayer
So the NIT was issued on 9/7/2020.
Yes, your lordship.
Okay.
Yes.
Now,
Petition-
so what has happened subsequent to that?
Your lordship may kindly see Annex 25 petition, your lordship.
No. Now you come to the affidavit in a position.
Yes, affidavit they have filed.
Paragraph 4.
Yes, paragraph 4.
Then it becomes infructuous.
Your lordship may kindly see the language and the the deponent web to state that as per the request of the superintendent of police, the NIT was invited for keeping the huge number of fish cattle by police. Smuggling of cattle was minimized. How? It is still.
Mr. Council, that is not an issue with this one.
Let them file a.
No.
Status
There-
report here.
No, there's no need of status report. Right.
Already it was withdrawn, lordship.
Here, the NIT has been cancelled.
Lordship.
There's nothing remains.
No order annex.
Huh?
No order.
How does it matter? We are recording it. His
When
affidavit is
can
there.
tell how, why can tell.
If you see, if you find out that any NIT has been acted upon, if the NIT has been, then you file a contempt, then we'll see. When they have said in their affidavit that the NIT was cancelled, that's enough.
In Simawat, even was on the basis of the honorable court order, lordship. to
Correct.
get NGOs.
Heard Mr. What is your name?
R. Majumdar.
Huh?
R. Majumdar.
R. Majumdar, learned counsel for the petition. Also heard Mr. K. Gogoi, learned counsel for the all the respondents. The petitioner is aggrieved by the action of the respondent in postponing a tender process initiated by notice dated 9/7/2020. It is the case of the petitioner that by the said notice dated 9/7/2020, comma, sealed quotations were invited from local NGOs for feeding and maintaining cattle seized by the BSF/Assam police. As a precondition, 30 bighas of land in the name of the NGO or leased in the name of the NGO had to be shown along with security deposit of rupees 10 lakh. The petitioner's case is that the respondent should act upon the tender notice dated 9/7/2020 and bring the same to its logical conclusion. Next paragraph. On the other hand, the state respondents in their affidavit in a position dated 21/1/2021 have at para 4 stated that GNIT has been cancelled. In view of the above stand taken by the state respondents, the writ petition has become insufficient. Accordingly, the writ petition is dismissed as insufficient. Right. You want to challenge the cancellation, you challenge. That's a different matter.
I am not on that. Yeah, lordship, I only pay for status report. What happened, your lordship, without any question, they are giving, this cattle to one private NGO without any protection process. I have Diamond Foundation, your lordship.
That's a different issue. That's a different, this is not anything to do with NIT.
There was the interim order not to give to any third party, your lordship.
It's expert at court order, Simawat, and lordship of various MD, not only one MD, various MD.
Yes, for export order.
Anyway, that is,
But who will maintain it? Will the police station?
we do not know. You file a PIF. Why do you want to maintain it? Why do you want to spend your own money?
Then the money due to protection, your lordship. Obligor.
Regarding patents of field by the outstanding
Huh?
amount of patents of outstanding amount of quantity. The respondent appears they have filed a file. In their affidavit also they have admitted that work has been done, my lord. Only thing, my lord, the last election, my lord, page 31, my lord. That is in 2022, my lord. This has been issued, the scheme is under CM Vigilance Cell, my lord. That is why work completed 2014. Because of these things. My lord, We allow other timers for it.
For what?
Plus, it is same business.
Huh?
Just highlight the same business.
So what?
The latest.
Huh?
Latest is not
What?
the latest status is not yet listed.
Who is, no, CM vigilance cell or not? If you, this matters of 22,
Yes,
then
it is under inquiry, ma'am.
what is the status of the inquiry?
So that will be allowed.
Supposing inquiry takes place, carries on for another 20 years, then what happens? What? Who is heading the CM vigilance cell besides the CM? Who is the bureaucrat? Who, chief secretary?
Home department.
Home department. You ensure that you get some status report with regard to this.
Take party.
Huh?
If your lordship make home department as party in this case, my lord, they will, yeah. Okay.
Same business, sir.
Similarly, citizen can I file application for increasing same citizen.
Are they here?
No.
Make them a party. Miss
Yes, they will be.
DS New York Learned Council for the
Yes.
Irrigation Department submits that the schemes against which work was allotted to the petitioner and for which the petitioner is claiming payment of bill, comma, is under investigation by the CM Vigilance. He submits that she does not have the status report with regard to the stage of investigation and whether the petitioner has indulged in any wrongdoing in respect of the work that he has undertaken. Yes, you obtain instructions. And Ms. DS knows shall obtain instructions with regard to the above. By the next day. This is the matter on. This is the matter after 2 weeks. You make an application in the meantime. All right. Mr. appears for the accountant general. That's it.
Yes.
All right. Yes,
My team is out of business, so kindly talk about that. I want to just sign it. We keep time there.
where is your affidavit? Are you filing anything?
Number 11. Yes.
Okay, right. On the prayer made on behalf of Mr. M. Hussain.
R.I. Mandal, on behalf of them.
M. Hussain. List the matter. When?
After 2 weeks.
Why?
2 weeks after.
Why after 2 weeks? We'll dispose it of. This is the matter after 2 weeks. Then next. No, 11, let us see. Affidavit is there.
This file has been loaded paragraph 10 to 13 years to the question. Turn on page 45.
This is for what? Compensation?
Compensation. Victim compensation.
The husband of the petitioner or what? What is this? Property reserve.
Husband of the petitioner.
Huh?
Husband of the petitioner witness as per the explanation.
So the husband of the petitioner is missing. Now, is there any police case registered?
This case was registered.
What is the police case number? Okay, Kasai Gaon. Now, what is the report? What is the status report?
Because report regarding police case investigation. Already trial is going on. Also. Otherwise,
Trial is going on?
Malon may kindly fill page 41. Page 41. This is a rejection order passed by the learned district and session judge. Page 41.
What has happened to the husband? Is missing.
Okay, as per the it is missing.
The earlier one also you make it 1 week, huh? The earlier one, item said you put it next Monday. We'll dispose it of it. Monday, it's coming Monday. Same order. Same. Monday. Yes.
Hello, may I please hello. I become my height figure, my lord. After my lord, they have issued a this order
NIT dated?
28/5 2021.
Huh?
28/5/2021.
28/5/21.
Yes, ma'am.
For what? NIT for what?
For my lord, apart 213, Unapur Sen and Gabriel Mahot.
So e-auction notice cancelled.
Yes, yes.
When? Notice cancelled when?
22/6/2022, ma'am.
22/6/22.
Yes, madam. Case number 62, ma'am.
So what is the latest now?
It is now lordship, since the process has been cancelled, we haven't put any new NIT, the lordship. We put any tender regarding this one.
So this e-auction notice has challenged. On what ground? Huh?
At present, madam, want to not to pursue this matter. We want to withdraw.
You're not going to pursue.
Yes, ma'am. Only, madam, my care is that, madam, at case number 62, madam, it will be acted upon by the authority. Okay. We can. I will participate, madam, upon the authority, if they tell me, they will put up again.
That will be according to them. We cannot direct.
It's not. Yes.
Okay, right. Okay, right. Mr. T. T. Gogoi learn, huh? T. Delhi. Mr. T. Gogoi learn counsel for the petition and submit that as per instruction, he does not wish to press this petition. But however, the state respondent should act upon the office order number 36 dated 22/6/2022 issued by the Divisional Forest Officer, Dhemaji Division, Dhemaji. Mr. R. Goel, current counsel appearing for the police department, subject that the that 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 the respondents to take a decision as to when a new e-auction notice will be issued. Mr. The office order number 36 dated 22/6/22 states as follows. Is as follows. Is as follows. Page 62. From here to office order special dated special issued by the division forest officer, the Maji division, Divaji is as follows. Is as follows. Basically, in view of the prayer made by the petitioner, the great petition shall liquid as not present. The respondent shall take a decision with regard when the e-auction notice can be issued in terms of the office order dated 22/6/20. Correct. Correct. What is the out here? What is the guessing that they are not entitled to that case back here? Why?
Because your lordship, this is not a drowning in a public place.
Where is
but
the scheme?
in your lordship, they have annexed.
This notification dated 27/7/2011. This is the one.
This scheme is actually a lordship of the SDRF. This scheme is actually for the person who get employed, who go and do the rescue operation. So this fund is regarding that. They have relied on the notification dated 8th of April 2015, page 35. They have also relied on this particular notification, page 35. There you note to point 1, ex gratia payment to families of deceased persons. 4 lakh per deceased person, including those involved in relief operations or associated in preparedness activities, subject to certification regarding cause of death from appropriate authority. This is another notification they are relying on. And 25,
Where does drowning come?
particular,
Where does the issue of drowning come?
that is what it is, your lordship.
Huh?
It's not mentioned here. Drowning is not mentioned here. Just relief operation.
Yes, where is it?
Also, lordship, an affidavit has been filed in this case
Okay, right.
where the
Adjournment prayer has been made on behalf of Mr. M. Hussain on the ground that he is out of state. The para 5 and 6, para 6 and 7 of the affidavit filed by the respondent number 7 states that the petitioner is not entitled to any ex gratia payment.
reported 5, your lordship.
Huh?
I'm mentioning the
Respondent number 5.
responsible 5.
Yes, is to the effect that the petitioner was not entitled to any financial assistance. Good, sir. This is the matter on Monday. We'll take it up on Monday, no adjournment that day. Application of 2000 number of the 459. Why don't you make Jal Shakti party? No, no, okay, but then you see, eternal issue, the problem is they're going to take the stand. Jal Shakti provides 90% of the thing, and then when the orders are not complied with, then what to do? This court has disposed of a number of cases, but that Jal Shakti is a party. Just make them party. We don't need their affidavit. On the prayer, the concept for the petition is the matter after 2 weeks. In the meantime, you make your application. Yes. Okay. So you file an affidavit. Affidavit might be to your favor. Okay, right. Mr. K. Goy submits that he has received instruction. By letter dated 18/3/2024, issued by the Deputy Commissioner of Police, bracket fine, Guwahati. He submits that he will file affidavit within 10 days. Within 10 days. This is the matter after 10 days. Yeah, they are saying that they are claiming less. Huh? I don't know. You might have to file a reply affidavit saying that yes, they are correct. And then make a prayer for the enhanced amount. That's why I'm not disposing. To give you a chance. Alright.
May I please, your lordship? Lordship, kindly adjourn the matter for today, lordship. Must speak out soon, lordship.
Why is it being adjourned all the time? You are not objecting. Okay, on the prayer for adjournment made
TCI Moran also on behalf of Deccan.
I'm paying with this, I'm paying with this. Just leave it out. No, on the paper, adjournment made on behalf of the
Mr. Deccan was some.
Mr. J.K. Prasad, Leonard counsel for the
Yeah,
AIGC. This is the matter after 3 weeks. Oh, that is why. That's why you're not objecting. You should object. I thought you were agreeing. Why are you not producing?
Recording is a different department.
This is the matter after 2 weeks. This is 2 weeks.
Can you get next week? I tried it. Just 3 seconds.
Okay, this is the matter in the next week. Interim order to continue to the next week.
Okay.
Hmm? Bills.
I'm for a number 120 for a liberty. One of the payment to make
Huh? Payment will be made within 3 months. In item 18, you write, heard Mr. K.P. Pathak, Lawrence Counsel for the petitioner, and Mr. G. Gogoi, appearing on behalf of the respondent number 126. You're the counsel.
Yes.
126. The petitioner's case is that by work order dated 19/12/2020 issued by the Assam Science and Technology University, comma. The petitioner was awarded the work for preparation of concept documents for construction of University Campus Roman 2. The said work was successfully completed and by resolution adopted in the meeting dated 10/1/2022 by the university authorities, it was decided that the architectural services provided by the petitioner would be paid at an approved rate of 2.25% of the total project cost, which was agreed to by the petitioner. The petitioner's grievance is that despite the bill for rupees 12,45,580 being submitted to the university authority, the payment for the same has not been made till date. Mr. So the land council appearing for the respondent number 1 submit them as per instructions received by him. The bill amount of rupees 12, will be paid to the petitioner within a period of 3 months from today or from the date of receipt of a copy of the file. From the date of receipt of a copy. In the above submissions made by the council for the respondent number 1 this petition is disposed of with the direction to the authority to pay the petitioner the bill amount of rupees within 3 months of the date of receipt of a copy. The rate petitions are accordingly disposed. Or is it different? Okay, wait. So this is again a different one. Is it? Is it same? Okay, but you have not made a difference here. Okay, you just see, huh? If I now 5193, the first one I gave was 5193, huh? Then in 5194, wait, just a minute. The work order is same also. Work order is same and everything is same. Out here it will be ASQ campus 2. It will be 2 only. Roman 2. Then again, and meeting minutes also same. Amount is only 12,70,601. That is in that 5194. Okay. Then in the 5261, out here it is work order dated 15/5/2020 and 26/6/2020. Okay. The two work orders, huh? Issued by census. Same thing. Same. Resolution dated same. Same. Only thing the amount is 7,51,414.56.
हमें पिक्चर और एफिडेविट नोटिस करेगा तो माइनर में डिस्पोजल का मतलब
Para 7. But you have not mentioned the amount. No, he has not mentioned.
only 10% negotiation.
Yeah, basically said that negotiation of 5%. So is that accepted? 9%, 5% has been deducted.
And then 10%.
The amount that you have given, is it after deduction of 5% or before? No.
10 was the actual.
Either we cannot dispose it.
Otherwise, we are actually dead on it.
So you see, Mr. Counsel, you have asked for payment of 48,72,793. Okay. Now we have just look at para 7 of the affidavit.
This amount is not roughly after deduction. It will be reflected from page 16.
Page 60 now?
Page 16 of the repetition. They have submitted a roughly haircut bill amounting to rupees 48,72,792.
Mr. Counsel, there is one thing. There in page 7, they have said something, para 7. Another thing, you are very unclear, Mr. Gogoi, that's your fault. You have to tell me, you have to tell the court, what is the exact amount? So you are agreeable to deduction of 10% from this 48 lakh? Then? So how can I dispose of? You obtain instructions. It's the case of another process for the respondent shall obtain instructions as to the exact admitted amount by the respondent in terms of para 7 of the affidavit in a position filed by the respondent number. So, this is the matter. Where? Why do it? This is the matter of two. Give me an order. Jal Shakti. Has the department got money now? They are giving money or you're only getting orders?
Order that you have on it.
That's what.
Yes, madam.
Are you getting the money?
You have not got the order.
But what to do? You have to clear.
May I take extra like state of
Yes, you have been instructions, I think. We are passing orders after orders. If they don't get money, then how will they pay? Thank you. You have Miss Eloda, no? What is your name? Eloda. Huh? TJ. You're for the 2 to 6.
Yes, sir.
This is very high amount, madam. You have received 1 crore 21. You're supposed to receive another 1 crore 30. Is again Morrigan or what? Where is the admission? Page? Is number 1052 or is it 052? Okay. Huh? For what? Okay. You are having a dispute, property dispute.
Then it is an order for swap. Interpreting that order. But still not by by protect this one by order. That was thereafter. There, now the second market.
Why won't they storing electricity?
That says that there is a application pending. It's ordered by.
So you are not fighting over property. You are the owner of the property. No,
I am the owner by
but someone else is also claiming title over it.
there is also some
So you are residing in that land. So this is basically once electricity is used, has been given to you, then what remains? So this has become infrastructure.
one other fair enough that was better by which the water pass. Now that communication I had made. And clarification.
Where is that order?
That order you're not. We 46. Part
Yes. Yes.
I mean, therefore, and also part when we stated so far as the parties are part of the so now this was the order to status quo. But I was having it before right?
There's a house.
There's a commercial.
Anyway, you see, we cannot, in a writ petition, we cannot set aside an order. Yeah, we cannot set aside a civil court order.
No, that cannot
And this has already been explained.
take place.
So then this you will just say that this matter become infructuous. Yes. There's nothing else besides that in this writ petition.
Apart from other direct.
That's why it will become infructuous. I heard Mr. D. Chakrabarti learn counsel for the petitioner. who submits that in view of the order dated 17/6/2019 passed by this court, this petition has become instructed. Mr. K.P. Pathak, Lawrence Counsel, appears for the APT. Before that, the petition council also submits that pursuant to the order dated 17/6/2019, the petitioner has been given temporary connection over. As submits that the electricity connection has been restored to the petitioner's uh, premise. Next one. Mr. K.P. Pathak appears for the APTC and submits that the petition has become ineffective. Next paragraph. The order dated 17/6/2019 passed in this case is reproduced below as follows. Next. In view of the fact that the only prayer made in this petition is for restoration of electricity, which has been done by the APTCL authority pursuant to the order dated 17/6/2019, the writ petition has become ineffective. Now, this petition accordingly dismissed as ineffective.
I will give the verbal instruction that funds are being received, Your Honor. Some funds are being received. The process is working. That time might have come after 1 week, but that get the hospital safe.
Mr. R.R. Gawai, Lawrence Counsel
For respondent to the
point number 2. Submit that some funds are being received and the matter may be listed after the list the matter after. It's already there.
public.
Okay, here we have given approved the CD proposal that has been sent by the Education Department on 21st of January. Lordship, as per Lordship direction, the order dated 29/4/2024, Lordship. There was a specific.
So sealing proposal has been approved.
Yes, Lordship, that was sent, and now on 21st of May, we have given the approval. Lordship, the third person here, he was here, he informed me that within a period of 10 days, maybe they can make the payment, but not present. The Finance department has done it. Now only the part of making the payment is there.
So the money is there with them.
Yes, sir. That is the approval of the system. They have approved. The money is with them.
Let me see.
Yes.
So where is Mr. N.J. Khattar?
What's your?
We list it next week.
Yes, Lordship.
Matter may be fixed on 6th
Maybe after 10 days, Lordship, because he said
next Thursday.
Next Friday,
Friday, Lordship. Yes, Lordship.
right, third, Mr. H. Aliha. Counsel for the Finance Department who submitted letter dated 21/5/2022. Issued by the Deputy Secretary to the Government of Assam, Finance Budget Department, which is to the effect that the ceiling proposal of rupees 84.68295 lakh for payment to the petitioner has been received on 15/5/24 by FOC number P-SE-0005. And the said amount has been approved on 21/5/2020. So we submit that the respondent who the respondent number 3 and 5 can now pay the said pending bills of the petition. This is the matter on next. On which date Mr. N.J. Khatane shall inform this court as to whether the said amount has been paid to the petitioner. Others remain non-compliant manner for 2 years. The particular term relevant is at page 51. Regarding royalty payment, generally secreted person, they have already got it. The judgment is at 36/22. Good for the other side. After payment manner, by your lordship has noted the order, page 2, order is 2524. That all the respondents appear before the court and explain why beyond 6 months to 6 months. Let it be taken up at 2 p.m. and information is. There is so many cases 2 p.m. 2 p.m. Huh? This is only for the purpose of the record. Right, application. And the people that go ahead and information, it is simply taken up on Friday, so you got some functionality. Okay, right, on the prayer of Mr. P. Gomez, who purportedly has some personal difficulties, is a matter of fact. Right, people. I think you have put the restaurant over part. Today we had this done. And in the future, allow to, I don't. What affidavit? This is a review. What affidavit you? What? Reply to what? It's very simple. And fix it. There. Where? When do you want, madam? A day before that or what? When do you want? No, 14 is too far. Set. Mr. P. P. Vora appears for the respondent number 1 and 2. And submits that he has filed Wakalat number today. This is the matter on. Said. For disposal. Yes. Yes. Yeah. Who's here? Here we have 38 for whom? For the respondent. For the petitioner. Which petitioner? Will file an IA. Pass it on to you. Some other day. What remark? What is this item? This is item 36. If he's not here, we'll dismiss. Here it is for the review petitioner. It's 38. Oh, 28. 28 to only finish. No one appears for the petition. Oh, this is the matter on Wednesday. The- Both all Mr. here. Yes. What remark? 2018 matter which is closed off. Huh? No more. It will be pending for too long. Yes. Where is what remark?
Come to the above paragraph.
Huh?
Last paragraph.
Where is the order?
Page
Huh? Page?
57 of the IA.
Yes.
Last paragraph about it.
Yes.
The above clearly goes to show that the petitioner had made the application for compulsory and appointed in the year 2005.
Just a minute. 57.
Last paragraph.
Yes.
The above clearly goes to show that the petitioner had made the application for compulsory and appointed in the year 2005, not in the year 2003. As has been protected by the respondent yet the decree of court. In fact, it seems that the respondent number 2 has been trying to mislead court by giving a wrong date, but the official records clearly give the fact the petitioner had applied for suspension and appointment in the year. Is the part one. Yes, please, go ahead.
So what is wrong?
Page 11, not paragraph.
Page?
Page 11, the paragraph.
Yes.
Also, here we have stated why exactly we are not at fault for this. That for this mission on our part. The paragraph 9, that it is stated that the then it is stated the original receipt register of comment the coming out. This way it comes out that because in the date application in the register, the date was mentioned, it appears it was not yet 30.
Huh?
It appears that the application was made in the 2005 law, which means quite a due diligence also it must be quite a due diligence also we did not the bona fide mistake on our part, for which not to clear photo statement that we are referring our of we can the respondent discussion is working on. Of the particular remark of the paragraph where the respondents have now initiated a criminal application against us, paying for compensation. Between we have to be so careful. What a reason was it?
You see, this court has gone through the record. What is wrong? You go to the division bench.
After going the original record, Pratik recorded.
Because I've gone through the record, but
And also, Pratik, I is not necessary. Once the distribution is disposed of section
Correct.
35 by filing side, Pratik
This-
won't
this-
actually say I have the right. Like, Pratik,
so
regarding the this one, nobody put it. And this one has this one also put it.
there's six paragraph.
Plus, paragraph 10 was in the first.
Hello.
Hmm?
Document passed order after perusal of the record. So defeated. Actually, I'm trying to have a 5 years, 5 years, not trying to assist that. What is our understand what is the since we are considered not up to I don't these are position of law. The kind of passing and adverse order. We have been we also have been because of the we could have extended private but not necessarily that because I also joined at a particular point of time. And I got particular statement that
You could have filed a review,
Yes. Or if it was
not a IA. Or go to the division.
document not so, but
Or you go to the division bench. You have gone to the division bench.
I got nothing here only on one thing like that. Not because order has been complied with. We have given appointment. Pain Vibhag has been taken care of. The pain Vibhag was that he was not appointed.
Appointment has been given.
yes, appointment given.
Immediate
It is not the issue. Since Pratik regarding the conduct law, Pratik itself has found that conduct. In spite of Pratik this record in hand, they were submitting that.
Oh, you filed a case against them for compensation.
No, not compensation, third party matter. 340 proceeding to initiate 340. Then after that, they have appointed. After filing that proceeding, 340. So that was second cognizance 340 would say application. Now it is pending. After filing that application was there upon my application, not before that. And logic, one more thing I will put logic being on knowledge of sport. What the conduct of this petition number 1, what he has done was after filing this criminal petition, this petition number 1 pressurized my client to put some signature in blank paper, stating that your appointment will be made very soon, yes, some signature is necessary. Then my client informed me over telephone that sir, this happening. So I telephonically informed that person. I given a text message that please return the document. Then the petition number 1, what he has done was using that signature of my client, he has sent me a notice. Lordship, I have annexed that notice also, stating that your Vinadeti is no longer interested to pursue this case. And same notification also said to the registry of this court that lordship will file. I have annexed that document.
Very Lordship, the conduct of, I am only on the conduct of the person. Lordship. Next, what he has done, Lordship, one day, Lordship, this number one, send my client along with one of his employees to my bar. When I was sitting in my bar, my client approached me. I didn't have any idea that someone is also there. Then, Lordship, my client was talking with me about this statement. That fellow was recording my statement in a mobile phone. Suddenly, Lordship, when I turned to the Lordship, I found that he is doing something. Then I Lordship touched the mobile phone. I found that he is recording my statement. Then Lordship, that person was brought to the bar association office. Then he admitted that yes, this Daras Mathur has sent this person to record my conversation. So this is the conduct of an IFS official. So Lordship, I am not pressing on the only regarding maintainability of the statement. This strategic business is not maintainable. And once the proceeding is going on, Lordship, and because of this person, Lordship, I have deprived 3 years salary. Had he considered my application in the year 2015, I would have kept salary from 2015.
That's
This is the conduct of it.
that's a different thing.
Yes, Lordship. The conduct of this process is the conduct of the process. The IFS officer, he must not have certain done this kind of process. Sending a person to my office, but
See there, my lord,
these are the facts.
if he is agreed by some other cause of action, he has got legal remedies by that. Here we are only for
No, I am not on that, but one thing, do you think a council will say all this? Which he cannot say to anybody, he's just saying it out, so I'm not saying, but then there's nothing to doubt here.
I'm not doubting it. If he is a legal remedy by that, he is agreed by that, not by that. Here
He's
we
just trying to buttress his arguments that,
And yes, and one more thing, Lordship, before filing the IA, they have not have copy to this meeting. Without having the copy, they moved on the first day. Lordship. So perhaps Lordship, personally, Lordship has detected that issue that where is the party, opposite party. Then on the Lordship,
no, I issued notice,
yes,
the order is there.
yes. Okay, it's a request of-
Issue notice, returnable in 3 weeks. It was done without you.
Yes, sir.
Yes,
So-
that's true.
It is a Lordship issue. Lordship will consider IA is not say anything.
It is
Regarding mandatory,
2008.
Lordship, whether IA is maintainable or not.
Don't press that purchase.
I am not pressing Lordship, only regarding maintainability. Because I myself have suffered with a step judgment I have given Lordship. In the year 2016, this Honorable Court dismissed my petition, saying that once a
Right.
petition dismissal, that cannot be effect.
Heard Mr. J. Patwari, done it found for the app. Also heard Mr.
They call it.
J. Parita, that's counsel for the writ petition. So, this is a application for expunging, for deleting the expunging the impugned observation made by the court in its judgment and order dated 26/9/2006, passed with WPC 5079/2009, which is as follows. In inverted commas, in fact, comma, it seems that the respondent number 2 has been trying to mislead this court by giving a wrong date. So how is this relevant?
One thing, only for one thing. Paragraph 8, but because said that the paragraph number 8 was referred as judgment of Brattirab. It does just say that expert has said that judgment of the co-scale bench is also binding on a bench of judges equal state and judgment given in ignorance of that ignorance of by inquiry. So since I have also referred a judgment of the court in the subject number 266.
Oh,
That much record.
so whatever. That's all. The petitioner's counsel submit. Next para. That the petitioner did not try to mislead the court by giving a wrong date with respect to the application for compassionate appointment submitted by this petitioner. It submits that the record of the applicant did not show that the petitioner had submitted an application for compassionate appointment in the year 2000. It submits that the record of the applicant showed that the petitioner had submitted the application for compassionate appointment only in the year 2000.
My lord, can I just, sorry to quick interrupt. My lord, in this case, when I filed the affidavit, the applicant, my lord, he has gone by the record, he was not in office at the relevant point of time. My lord, there are two aspects which the lordship will take note of. In para 8 of WPC 1652 at page 21, if your lordship will kindly have for a moment, sir, of the, of the IA. IA factor. Yes. That the petitioner submitted an application dated 23/10/2005 before respondent number 2 for her appointment on compassionate ground. The said application of petitioner was forwarded by respondent number 3 to the respondent number 2 for consideration by forwarding letter dated 25/11/2005. So my lord, initial application was filed on 23/10/2005 and which was forwarded on 25/11/2005. Now please come to the second petition, my lord. That is 5095.
Where are you reading all this?
Yes. For all that, what I'm trying to
Where are you reading all this? That's not
from the IA, my lord. IA 3163, by which we are seeking expunging that particular observation.
Which para are you reading?
I was page 21, sir, para 8. This is the writ petition which was filed by the petitioner. Page 17, the writ petition starts. Page 17, 1654/2009. Please come to page 21, para 6. That the petitioner submitted an application dated 23/10/5 before the respondent number 2 for her appointment on compassionate ground. The said application of the petitioner was forwarded by respondent number 3 to the respondent number 2 for consideration by forwarding letter dated 25/11/2005. Then the Lord will kindly come to page number 39. In fact, the WPC 5079, again filed by the petitioner, starts at page 35. And please come to page 39. That the petitioner being eligible to be appointed under the said die-in harness scheme submitted an application of 25/11/2005 before respondent number 3 for her appointment. The said application of petitioner was forwarded by respondent number 3 to the petitioner for consideration by forwarding letter dated 25/11. She herself is contradicting. In the first petition, she said the application was filed on 23/10/2005. Now she says it was filed on 25/11/2005. What had happened, my lord? Along with this, actually nothing was filed on 25/11/2005. It was perhaps filed on 23/10/2005. But that was, my lord, continued by another representation on 8/9/2008, which was, my lord, processed by the authority and order was issued. Now, that is the problem, my lord. We never intended to make any now please come to, my lord, page 4 of this, page 5 of this affidavit. This IA. Para 3. That it is respectfully stated that thereafter the opposite party filed another writ petition in August 2015, that is WPC number 5079 of 15, again praying for consideration of her case for appointment on compassionate grounds. Further, at paragraph 6 of the said writ petition, the opposite party specifically stated that she submitted her application on 25/11/05 before the commandant, first AFPF, and the said officer in his turn forwarded the same to the PCCF Assam. As would be noticed in both the writ petitions, opposite party mentioned two different dates. Interestingly, opposite party conveniently refrained from disclosing about her subsequent application for compassionate appointment dated 8/9/2008, which was also forwarded by the commandant, first battalion, while later dated 20. Then Milord will kindly come to the next page, Milord. Now, page 46 is the second application filed by her. She has not mentioned about this application anywhere. Anyway, my lord, she has got the job on the strength of your lordship's order. With due respect, I have the honor to inform you that my husband, late so died on so on duty. He is only earning member of the family with three school-going children. In this regard, I would like to request you to kindly consider my case as simply an appointment compensation. In fact, my lord, in the original record, the original application which was forwarded by the commandant on 5/11/25 was not received. And I was not in office when, my lord, the original application was done. Subsequently, when 8/9 was filed, I was there. So that's why I made this statement. And all that we are praying is, my lord, at page 58. On top. In fact, it seems that respondent number 2 has been trying to mislead this court by giving a wrong date, while the original records clearly gives inference to the fact that petitioner had applied for compassionate appointment in the year 2005. My lord, we have stated in the original record when I was holding the office, that was not brought to my notice. I am a PCCF, my lord, I am sitting in Goa. Our only prayer is this expunging this remark. Otherwise, she has got the job. That's the only limited thing.
What about this order passed by coordinate bench?
Order passed by my.
It says that no miscellaneous application can be filed in a writ petition to revive the proceeding.
For that, my lord, that the permanent case. I think that AR 87 Supreme Court.
No, this is, it says Supreme Court. Yes,
My lord, this is
from
not-
that.
my lord, I am not seeking anything on merit. All that I am saying is for expansion of a remark. Lord, the lordship discretion, my lord.
I do not
For the
know.
ends of justice.
It says it is too well settled that
No, my lord,
when
we are
the
not- I am
proceedings
not
stand
seeking-
terminated.
I am not seeking anything on merit. I am not saying. All
No,
that I-
but what about the law? What about the law? It says here it is too well settled that when the proceeding stands terminated by final disposal of a writ petition, it is not open for the court to reopen the proceedings by means of a miscellaneous
Yes,
application.
we reopen in the sense, my lord, if some other directions are called for,
Yes.
or if any error is thought to be attributed, then I appropriately review application. But then, my lord, review of the honorable.
But this is not a review. We have not filed a review
I am
petition.
not filing it. No, my lord, this is again under Article 226. Your lordship knows in Supreme Court 1963 says that review is under 226 only. And we don't file, there is any provision in the constitution for filing any IA. So everything is under 226. Lordship will not go by the, my lord,
I know this is an order passed by a coordinate bench. This is by Justice Manojit Puyan.
no, my lord. My lord, this judgment is again based on the AR 87 Supreme Court.
This is
No, I am not saying no.
this
I
is
am not seeking
interpretation.
anything on merit.
Maybe.
All that I am seeking is, I know, that's my humble submission.
No, you have got to show me that I can go into this by way of this IA. Because out here it says that I cannot.
Okay, my lord. If the
That is the
lordship,
thing.
if the lordship gives an opportunity, I'll come up with case law to support my contention that in an appropriate case, even by filing IA also, this can be done.
But every rule has an exception.
But then,
Supposing, my lord, there is an error apparent on the face of the record.
then review
Supposing
the,
instead of filing a review, an II is filed, will your lordship not correct it?
but what to do when a coordinate bench has given this? Where I cannot go as I like. I have the judicial propriety demands that I follow the coordinate bench or I refer it to a larger bench. Because he has brought out this issue now, what I cannot turn a blind eye. I have got to answer his question also.
So, my lord, it has been a case when on the prelim of marriage, I am asking for something. I'm all the time saying it. I'm seeking expansion of a remark. Normally, these are all filed by either. I think I myself have moved 2, 3 petitions, my lord. In some cases, order has been passed. In some cases, of course, it was not passed. But on that maintainability issue, it was never raised by me.
But then this is
No, your lordship is not going to charge the merit of the order.
Oh.
Substratum of the order will remain. All that we are saying is expansion of a particular remark. And then, my lord, I have retired from service. It's not, but my lord, when that was something which I never intended.
no. You see, I will get it ready. You give me some citations by within 2, 3 days.
I'll try my.
If you give, then I will see.
I'm also in learning step of it. I have also sometimes contacted with my
No,
son.
there is nothing like it. My lord.
Thing is,
Yes, that's still.
I have suffered twice. Now this judgment. So that is why I have preferred this judgment.
No. Since you have brought it up, I have to answer it. I cannot turn a blind eye to it.
That's why inner logic something to be done.
In fact, my lord,
Again,
I may with all sense of sincerity and making it sufficient. The first law on this point is AIR 1987. That Parmanand, if I'm not mistaken.
It is
See my
Brahmdat Sharma.
Brahmanand, sorry, Brahmanand. Brahmdat.
Brahmdat.
Yeah. My lord, I'm sorry, I forgot the name. We'll have to see, my lord, on website. Anyway, my lord.
Facts are slightly different, but still. Now, since it has been interpreted in such a manner,
We'll try to satisfy you.
since it has been, so I will,
It is on Friday, my lord. If my lord will give us 5 minutes time at 2 o'clock. Or on Monday next.
Friday,
Right.
whatever I said, I'll keep that order. So, next para. We further submit that a perusal of,
What time permission can I take?
yes, a perusal of para 8 of the writ petition in WPC 1656 of 2009. States that the petitioner submitted an application for compassionate appointment on 23/10/2000, while in para 6 of WPC number 5079 of 2015. The petitioner has 39. The petitioner has stated that he had submitted an application for compassionate appointment on 25/11/2000. The petitioner submitted that the petitioner had mentioned 2 different dates for submission of an application for compliance appointment. That is 23/10/2005 and 25/11/2005. However, the writ petition abstained from disclosing the fact that another application for compassionate appointment dated 8/9/2008 had been submitted, which have been submitted to the department. Submit that the review is submit that the applicant was not aware, was not brought to the notice of the fact that the petitioner had submitted applications in the year 2000. And as the applicant had failed to observe that applications had been submitted by the petitioner in 2010, the applicants were incapable of misleading the accordingly based on influent observation should be expected from the that's an order date 26/9/2000 passed in W 65/079 of 2015. Okay. Next up, Mr. A. Karikan Learn Council for the application petition submit that this for that a coordinate bench has held that when proceedings that stood terminated by final disposal of a writ petition, it was not open for the court to reopen the proceedings by means of a miscellaneous application. In this regard, he has referred to the what is the order dated? It is not they refer to the order dated that
I'll keep it.
passed
I'll keep it.
passed in WP passed in MC 471/2015 in WPC number 266 of 2015. Inverted commas Srimati Nayan Das alias Basana Das versus the Union of India. He has also relied upon the judgment of the Supreme Court in the case of State of UP versus Shri Ram Dutt Sharma, BATT, Ram, BRAH. AIR 1987 SC 940. Mr. K. Chaudhary, learned senior counsel for the response. Space for time to obtain citation. To produce citation. In support of his stance that the present application, this application is going to. This is a matter of fact. But in between they have ran this whole part to reduce. And if it's first June, then you cannot have your cake and eat it too. You are billing from first June.
What I am saying is that the order which has been passed, because in second case, my prayer is, please consider my representation as per provision of section that clause. That full, lengthy order is there, because in the similar circumstances, they have given it to others.
That is the difference, whether they have
They
given,
will consider it and pass it.
then let them pass an order. No, there's no such
order.
thing. Let them pass an order.
And after that, when because my lord, this petitioner, he has taken loan from the bank on the basis of this 3 years contract.
No, if you take that into question, then
No, no,
you
I-
see,
because your
there
lordship
has to be a level playing field for everyone.
No,
Others
in the
also.
second case, your lordship will can receive. First case, one of the impugn the NIT which has been shown, that itself is in violation of the principle of legal justice.
But
Without any,
because-
that is NIT in the midst of my contract.
No, so that has not been, so the thing is that no prejudice has been caused to you because you are still continuing your contract till then.
Now I'm continuing.
Yeah.
Now it's your lordship dispose of the petition, the NIT and the order which has been passed. It is going to cast, it is going to infringe my right also, that the order which has been passed, that inform that the contract shall be terminated on 31/12/26. This has to be set aside. On the ground that you have no reason.
No, that communication has been become redundant for the simple reason that you have continued.
And second case, your lordship will send it. Second case, your lordship will send it. My prayer is that only. Here only additional statement which I would like to show is that the pass a speaking order on the representation inspection. The detailed order has been already recorded. In second case, my lord, your lordship is looking into second case.
Yes.
Yes, second case, your lordship is looking. There is already a direction to pass off. This order may be passed after hearing.
There is this letter issued on 28/5/22 to you. It says the subject job has been awarded to your agency, so and so. The site for the subject job is handed over with effect from 1/6/22.
That is true.
You are requested to commence the job with effect from 1/6/22. And then you have given your bill, so it is as for 1/6.
That is, 1/6, your lordship.
So it ends in 30th May.
31st.
30th,
31st.
31st? 31st. 31st. So it ends at 31st May. Only thing is that you take a decision on his representation within this time period.
Speaking order.
Speaking order or not, that there's no requirement of a speaking order.
It will depend on them.
There's no requirement of a speaking.
But I will show one judgment with the kind of context is not that tight thing, but this no judgment is diluted. The lordship may remember that one ambulance and a 6 days delay was there. They were not accepting. As the lordship said, I cannot do anything. We got relief from this division bench on the basis of this.
Okay.
Because contractual matter, they cannot, in view of this clause, they have to pass it because my right has been infringed.
No right accrues to you.
On the basis of this, I acted. Your lordship will kindly see, I acted on what sense? Page 103, my lord.
Yes.
Second page. Page 101. No, sorry, my lord, page 55. The lordship may overlook that.
Page?
55. These are the loan periods which I am recording. Yes, I'm just because your lordship is not inclined to take note of it, I'm just pointing out. Page 55, I'm required to pay loan from 10/7/22. Page 55, your lordship.
Mr. Council, everyone takes.
I know, but
That is neither here nor. Page 55.
yes, yes. I've taken loan and my repayment schedule is 10/7/22 to next page 10/6/25. Because it is a 3 years, 2 years plus extendable by 1 year. 2 years might not provided my conduct is good.
Let them take a decision.
Yes, let them take a decision and if they hear me, man, that it is good, so that I can point out
Let me see that judgment. In the division bench.
division bench. That is a different concept.
Okay, right.
And this. And the judgment which I am relying is 2023 QSC. 703
2023,
2 SCC 703
703.
703. Here there was a delay of 56 days in commencing the project. The court, I think, with the latest judgment, court has dealt with all the aspects of the matter in regard to contract and ultimately says, termination of contract results in the deprivation of the valuable rights. Which has ultimately the court said, no, you, the termination of the contract is. Paragraph 190.
This is infrastructure.
That's the division that ultimately order was. He got
The single bench had infrastructure, division bench had infrastructure. That's what we, yeah, that's the order, that's the.
he got released.
Anyways, why have we submit the wrong order?
These petitions were in fact, because we got released. Other two petitions were discussed pending before the single yard. This year, the release given by the division yard. Those two petitions. I'm not on that. What I'm saying is that, now, reasonable expectation in view of clause 8. Clause 8 that Mr. Lordship is looking into, code right. Second page says. 2615 to 24. Page 47. I'm just reading this, my lord, your lordship, because this gives me a lot of expectation. Reasonably, my lord. I'll just read this, my lord. May I, ma'am? Yes. Initially, the contractual period of the work shall be 2 years from the date of commencement of the work and placement of the vehicle. The work order may be extended for 1 year on the same rate, terms and conditions, depending on satisfactory performance of the contractor at the discretion of the contractor. Now, at the discretion. Yes, discretion. That is on the another part. So 2 years, I am required to give satisfactory performance. So my knowledge, I have given full satisfactory knowledge. And suddenly, why this action has been taken against? And that also, in the midst of the contract. So in the midst of the contract, they wanted to terminate it and they have issued NIP. And I am giving, my lord, your lordship can you see page 114. Yes, page 103, ma'am. Yes. So with due respect, we would like to inform you that a contract-wide work order number 12 awarded to Objara Enterprise, Nulmati, Guwahati for a period of 2 years with extension of 1 year, 1 year. In connection of the same road permission has been for the following 7 vehicles. You are requested to issue road permits for the above mentioned vehicles against the above mentioned fund. So accordingly, permit was given. Now page 11149. First is page 111. Similar contract has been awarded to the petitioner in respect of the some other work, and same clause is there, A, and extension order is at page 116. In connection with our letter, earlier letter of acceptance for the subject work, this is to inform you that this contract has been extended for a period of another 1 year, up to so and so, at the same date, terms and conditions, total fund. So similarly, my lord, I have annexed at page 118 and 122. The other job.
So let them
therefore,
take it, let them take a decision.
Let me take it. What I am saying, my lord, that can hear me so that I can point out which the difficulty is.
No, let them take it.
Just we just first point on the overwhelming public interest in interim orders, and if a person accepts a contract, he must accept the entirety of the contract, not just some that are advantageous to it. I have asked that. That's all.
How is this relevant?
So we are relying on that extension clause and saying that if you cannot just read one clause in isolation or one line down there.
Ah, that is there. Just in the station, that the section part given. It just,
Consider my requisition time, and if they reject it, further, so that I may get a chance for person.
But that will be considered, but let them participate in still open. It's just still open.
Not
Yeah.
now,
yeah?
not now, not at this stage, but let them consider my
After
requisition.
rejection, matter what the.
But you will not be allowed to work from first.
Let's consider.
You dispose of his representation within 1 week. Thereafter, if it is rejected, you give him 1 week time to, you give 5 days time to submit his bid.
Or minor fee.
Huh?
It's 1 week.
1 week bid.
So let them submit the bid, we will not open.
They cannot,
We will not open.
because
If we reject it, we will not.
these are all other disciplinary.
Because if the technical bids of the other 5 bidders are open, then that's it. There are other 5 other bidders. So let him submit his bid also in the interim, we will not open that bid. And if in the case his representation is rejected, then the bid is rejected.
The permit is in the name of the Ayod. 3 years permit is in the. But they need the vehicle, we cannot run the vehicle for any other. So that.
Anyway, right.
Taken to. What is the clause of, what is the clause eight of that?
No base of the bid.
That is my submission. I thought they will also give reason why they are not accepting. If they have good reason. My performance is not satisfactory. I think 40%.
Para 7. No, Para. Para 6. The counsel for the respondent number 6. Counsel for the IOCM for the submit. That the petitioner was issued letter dated 28/5/22 by the IOCM, which stated that the site for the contract work had been handed over to the petitioner with effect from 1/6/2020, and he was to commence his contract with effect from 1/6/2020. Further, the petitioner has been submitting his bill for the hiring charges of all the vehicles with effect from 1/6/2020. So from that fact, the contract has has having commenced on 1/6/2022. The same expires on 31/5/2024. And Mr. P.D. Das, the learned senior counsel for the petitioner, submits that the inconsistency in the observation made by this court in the order dated 4/23 passed in WPC 7005/2020, comma. The third paragraph of the synopsis in WPC 2615 of 2023 are not correct. No, and are not correct. He, however, submits that the petitioner has submitted bill for payment for hiring of his vehicles from 1/6/2020. As such, the contract period would have to be considered to have started from 1/6/2020 and would end on 31/5/2020. He submits that even if the contract period is to end on 31/5/2020, the petitioner's representation stated, what is it?
4/5/2020.
Huh?
4/5/2020.
4/5/2022, 24, praying for extension of the contract period for 1 year. Has to be decided by the authority. In terms of clause 8 of the special conditions of purchase. I have heard the learned counsel. As can be seen from the submissions made by the counsel for the party. The communication dated 15/5/2023 issued by the IOCL to the petitioner, informing him that his contract would terminate on 31/3/2020, has become redundant, in view of the fact that the petitioner has continued to hire his vehicle to the IOCL pursuant to the NIT dated 4/3/2020, which contract period? No, first stop. The contract period. No, full stop. The further. The NIT dated 18/11/2020. The new NIT dated 18/11/2023 for hiring of vehicles for another 2 year term has not affected the petitioner's contract, which is going to expire on 31/5/2020. Next slide. No. So, however, in view of clause 8 of the special conditions of contract, providing for, which provides that the work order of the petitioner may be extended for 1 year at the discretion of on the same rates, terms and conditions, depending upon the satisfactory performance of the contractor at the discretion of the IOCL. This court is of the view that the petitioner's representation dated 4/5/24 would have to be decided by the respondent. Pushpa. Next para. Clause 8 of the special conditions of contract is as follows. This is at page 47 of the 2615. Where is that? The contract when it is to start? That
Clause, if there is a first
the site handover.
site handover.
Where is that? 1/4. Huh? 14.
Clause 4, page 31. 31 would be of the same 2615. Page 31. Clause 4. This is the NOA.
31.
Page 31.
The new
The work order. This one. 4.0 completion time.
But in this para 3A, no, you're right. Clause 4.0 of the special conditions of contract states that the start of the contract shall be reckoned from the date of handing over of site. The work order. Which is the work order? Is it? Not special terms of the contract work order. Yeah, and not special to 4.0 of the work order. Is the received communication from the date of handing over the offering. Just say that, huh? That's all. Then next. Whatever I said, the last paragraph is. No, that is at paragraph 3.8, not that. That can be seen from the above clause 8. The respondents have to take a decision as to whether they want to extend the contract of the contractual period of the petitioner in terms of the conditions therein, which is as per the discretion of the corporate. Next, on considering of the above facts and circumstances, this court is of the view that the respondent should take a decision on the petitioner's representation for representation for extension of its contractual period within a period of how much time do you need? 5. Within a period of 5 days from today. From today. Pusta. The petitioner. No, first of all, in the then the petitioner, then as the petitioner has not submitted any bid pursuant to the NIT dated 18/11/2023. The petitioner should also submit, is also granted a week's time to submit his bid pursuant to the NIT dated 18/11/2023. In the event the respondents come to a decision that the petitioner's contractual period should be extended for another period of 1 year, comma, the tender notice dated NIT dated 18/11/2020 should be cancelled.
He recalled by issuing appropriate code.
Maybe should be cancelled, that's recalled by issuing an appropriate order. That's all. The writ petitions accordingly disposed. Writ petitions are accordingly disposed. Common order. IA, you make it separate. In view of the order passed in successor. This is part of the record or not?
Let us keep it as part. This is the original. I will present a photocopy.
You pick.
So this is part of.
Why is it not? Anyway, this doesn't help much. Not required. Because he's already given the bill
Yes.
from for 1 6.
I was yesterday when I was going to the place. Permit is dated so and so, how can you supply now? Now they are saying, no, we have given
We are given old vehicle.
old vehicles for this, all this.
That is why we needed the bill to clarify.
And the cars, even though they run inside the refinery premises, because that is a huge area. So they carry the employees within the walls of the facilities. There is no public.
School bus.
Bus in school.
Apply you. They have to be paid, correct.
No, only they are my not saying about the pass of that. They will dispose of the hearing us, my God.
No.
But I can show them that satisfactory possibility.
It's necessary by here. We just go, we need to explain the difficulties of the topic.
Yeah.
I also talk to my clients, that has become expensive. The only thing was we work out 15 days,
Item?
I can force. Not taking out straight. Later relating to a lot of contract to experience. We didn't say anything, but thereafter also take period is already been over and new party has also been accepted.
So it has become infracture.
Now only my prayer is that we have to get some money from Think University. Although we are not made any prayer, we'll make a representation of this.
That you do, you take up, so he'll be entitled to get his, will he be entitled to get it back? Huh?
So let me make a representation.
That is not part of the writ petition. Right, Mr. S.C. K.R. Leonard Counsel for the petition. Submits that. The writ petition has become infirm. So Mr. R.R. Gowai, Leonard Counsel for the Forest Department, huh? Agriculture Department, Agriculture University, submits that this petition has become infected. In view of the fact that the work order has been issued to one MS Vanguard Security Service and System to take over the security coverage of Assam Agriculture University, Jorhat, with effect from 1/1/2024. By letter dated 28/23 issued by the Registrar, Assam Agriculture University. In view of the submission made by the council for the parties, the writ petition is closed as dismissed as infracted. The letter dated 28/12/2023 issued by the Registrar AAU is made a part of the record and marked as an X.
If any amount is due, we can make representation.
If any amount is due to the petitioner as per law, the same should be returned to him. No, it seems to be returned to him. Okay. That's all.